The term assault weapon is at the heart of America's gun debate, but it's not a technical term, it's a political and legal one. These are semi-automatic firearms, firing one round per trigger pull, often resembling military rifles due to features like pistol grips and detachable magazines. Supporters of bans argue these features make them especially dangerous and frequently used in mass shootings, while gun rights advocates say they're functionally no different from other semi-automatic rifles. For millions, rifles like the AR-15 are modern sporting rifles, valued for their modularity and reliability. The real conflict is about perception and purpose. Are these weapons of war, or lawful tools for self-defense and recreation? This fundamental disagreement shapes the ongoing legal and cultural battles over gun rights in America. Without a federal ban, states have taken the lead on assault weapon regulations, creating a patchwork of laws. As of late 2025, 10 states and D.C. ban the sale or possession of certain semi-automatic firearms, each with its own definition and scope. Many bans were enacted after mass shootings, like Connecticut's response to Sandy Hook. Some states, like California, ban rifles with just one military-style feature. Others, like Washington, focus on new sales but allow current owners to keep their guns. This patchwork means a gun legal in one state could be a felony in another, fueling legal challenges. Gun rights groups argue this inconsistency violates constitutional rights. These disputes have pushed the issue toward the Supreme Court, setting up a decision with national consequences. The fight over assault weapon bans is a clash of constitutional rights and public safety. Gun rights advocates argue the Second Amendment protects these firearms, which are in common use for self-defense and sport. They cite Supreme Court precedent, especially Heller, to claim bans on popular rifles, like the AR-15, are unconstitutional. States and gun control groups counter that assault weapons are unusually dangerous, designed for military use, and not protected by the Second Amendment. They argue these features make the weapons exceptionally lethal and ill-suited for civilian life. Supporters of bans point to mass shootings as evidence of the need for regulation. Both sides invoke history and legal precedent, forcing courts to weigh constitutional text against modern realities. The outcome hinges on how the courts interpret the Second Amendment's scope. In two Supreme Court cases define today's gun law battles: District of Columbia versus Heller in 2008, and New York State Rifle and Pistol Association versus Bruin in 2022. These landmark decisions have fundamentally shaped how courts, lawmakers, and citizens understand the Second Amendment and the limits of government power over firearms. In Heller, the court affirmed that the Second Amendment protects an individual's right to own firearms for self-defense, especially within the home. However, the justices also made it clear that this right is not absolute. Certain restrictions are allowed. For example, laws banning dangerous and unusual weapons, or restricting gun ownership by felons and the mentally ill, were deemed constitutional. The common use test from Heller became central to future debates. This test says that arms commonly used by law-abiding citizens for lawful purposes, like self-defense or hunting, are protected by the Constitution. This standard has been used to evaluate which firearms can be regulated or banned. For years after Heller, lower courts tried to balance public safety concerns against individual gun rights, often upholding state bans on certain firearms or magazine capacities. Judges weighed whether regulations served a compelling government interest, like reducing gun violence, while still respecting constitutional rights. But in 2022, the Bruin decision changed everything. The Supreme Court rejected these balancing tests, declaring that gun laws must be consistent with the nation's historical tradition of firearm regulation. Modern regulations now have to be justified by clear historical analogs from the 18th or 19th centuries. Now, states must show a clear historical precedent for any modern gun regulation they wish to defend in court. This new approach has made it much more difficult for states to justify restrictions on popular firearms. Gun rights advocates argue that there's no historical tradition of banning widely owned rifles like the AR-15, and that such bans violate the Second Amendment's core protections. On the other hand, states and gun control supporters point to historical laws that restricted especially dangerous weapons, arguing these are close enough to justify modern bans on assault-style firearms. Under Bruin's new standard, the burden is now on the government to prove that any gun regulation has a clear historical analog. This makes it much harder for states to defend assault weapon bans and other modern gun control measures in court. The Supreme Court's demand for historical analogs has set up a direct confrontation over the future of gun laws in America, with both sides preparing for a new era of legal battles. The outcome of these cases will reshape the legal landscape for gun regulation in America for generations to come, influencing not just current laws, but how future courts interpret the Second Amendment. Since Bruin, the Supreme Court has sent mixed signals on gun laws, upholding some regulations but sidestepping direct rulings on assault weapon bans. In 2025, the court declined to hear challenges to bans in Maryland and Rhode Island, leaving lower court rulings in place. However, conservative justices issued strong dissents, signaling they believe such bans are unconstitutional under Heller and Bruin. Justice Thomas argued that rifles in common use, like the AR-15, cannot be banned outright. Justice Kavanaugh predicted the court would soon have to address the issue directly. These statements put lower courts and the nation on notice. The legal foundation for state bans is shaky. A decisive Supreme Court ruling on assault weapon bans now seems inevitable. In late 2025, the Supreme Court agreed to hear challenges to assault weapon bans in Connecticut and Illinois, signaling a major turning point in the national debate over gun rights and regulation. The decision to take up these cases immediately drew intense attention from both advocates and opponents of stricter gun laws, as the outcome could have sweeping consequences for the future of firearm legislation in America. These cases, one from a state with a long-standing ban and one with a newer law, set the stage for a broad, nationally significant ruling. The legal questions at stake go far beyond the borders of Connecticut and Illinois, raising fundamental issues about the balance between public safety and constitutional rights. During oral arguments, conservative justices pressed states to provide historical examples of banning common firearms, examples that proved elusive. The justices' questions reflected a growing skepticism about the constitutionality of modern gun restrictions, especially when those restrictions target weapons that are widely owned and used by law-abiding citizens. Legal experts now widely expect the court to strike down state-level assault weapon bans. Many analysts believe the court's conservative majority is poised to expand Second Amendment protections, building on recent decisions that have already limited the government's ability to regulate firearms. The likely reasoning: rifles like the AR-15 are in common use and protected by the Second Amendment, and states haven't shown a historical tradition of such bans. The court may argue that, unless a regulation is deeply rooted in the nation's history, it cannot survive constitutional scrutiny, especially when it affects millions of gun owners. If the court rules this way, it would end these bans as a policy tool. State legislatures would lose a key method for addressing gun violence, forcing lawmakers to seek new approaches and igniting fresh debates over how best to protect communities. The decision would reshape gun laws nationwide, affecting not just Connecticut and Illinois, but every state that has considered or enacted similar bans. The ripple effects could be felt for years, influencing future legislation and court battles. The era of state-level assault weapon bans may be coming to a close, marking a profound shift in the legal landscape and sparking new questions about the future of gun policy in America. The Supreme Court's decision to hear these cases has sparked intense reactions. Gun rights groups see it as a long-awaited victory, arguing it will restore constitutional rights and end the confusing patchwork of state laws. Legal experts sympathetic to this view say Bruin left little room for bans to survive. Gun control advocates, meanwhile, warn that striking down these laws will increase gun violence and tie lawmakers' hands. They point to data showing assault weapons are often used in mass shootings, and argue these bans save lives. State officials defending the bans say the court is ignoring the dangerous and unusual exception from Heller. The divide is deep, and both sides see the coming decision as a turning point for American gun policy. If the Supreme Court strikes down assault weapon bans, the impact will be immediate, profound, and felt in every corner of the country. This decision would not just be a legal ruling, it would send shockwaves through American society, affecting millions of people in the different ways. Laws in 10 states and Washington, D.C. would be instantly invalidated, making AR-15 style rifles and similar firearms legal in places where they have been banned for years. For many, this would mark a dramatic shift in what is allowed in their communities, changing the landscape of gun ownership overnight. Gun shops would likely see a surge in demand, with people eager to purchase firearms that were previously off-limits. For millions of Americans, this would be seen as a restoration of their constitutional rights, a long-awaited victory after years of legal battles and political debate. But for others, especially those living in states that supported these bans. The change would spark deep anxiety and renewed fears about public safety. Many families would worry about the potential for increased gun violence, and communities might feel less secure as a result. The ruling would energize both sides of the gun debate, intensifying activism and political engagement. The focus of the fight would likely shift to other gun laws, like background checks, red flag laws, and restrictions on high-capacity magazines, as advocates and opponents look for new ways to shape policy. The decision could quickly become a major issue in upcoming elections, influencing campaigns at every level of government. Politicians would be pressed to take clear stances, and voters could become even more divided along partisan lines, further polarizing the country. While the legal question may be settled by the Supreme Court, the cultural conflict over guns in America will continue to simmer. The ruling may close one chapter, but it will open many new debates in homes, schools, and public spaces. The debate will move from the courts to legislatures, city councils, and community meetings, as Americans grapple with what this new reality means for their daily lives and their sense of safety. Ultimately, the Supreme Court's ruling will answer a constitutional question, but it will not resolve America's deep divisions over guns. The conversation, and the conflict, will continue, shaping the nation's future for years to come.